Hello, we're here at my office in Biloxi, Mississippi, and my name is Natalia Porsche. I am an attorney licensed in the state of Mississippi. I practice family, immigration, and criminal defense. And we're here today with my friend Clayton, who has some questions about divorce. And I guess there is a question that he would like to ask me, and I will answer in the best way I can. So let's hear the question.
Okay, so if a guy wants to get divorced in Mississippi and he wants to get immediate use and possession of his house, how can he go about doing that in the process of getting divorced?
Okay, so I guess the question is, if when he files for divorce, it will take for a while for the divorce to get finalized, right? Mm-hmm. And the question is what he can do to get the temporary use and possession of the marital home.
Right.
Okay, all right. So what he can do is along with his complaint for divorce, he can file a motion for a temporary hearing. So in that motion for temporary hearing, which will be heard really soon because it's summons Rule 81 after the other party is served, in that motion for temporary hearing, he must allege that he is looking for temporary use possession of marital home. So what he must show under Mississippi law in order to gain that temporary use and possession of that home, I guess that's the question. Okay, well, first of all, he must show that he's paying a mortgage, right? If we have a mortgage on a home, a marital home, he must show that he's paying mortgage, that he is contributing, okay? And the judge, of course, will look at who pays a mortgage, right? If we have both parties who are paying mortgage, then we have a little bit different situation. But let's say if he's paying mortgage, then he will just keep paying mortgage, and the wife can move out, and he can stay in the house for a temporary time before divorce is finalized. However, if we have two parties and we have a minor child, right? Let's say if this guy in this hypothetical friend of yours or whoever, they have a minor child. And that would depend on the custody arrangement, okay? In a lot of circumstances, when we don't have any domestic violence involved, the judge can grant a temporary joint legal and physical custody for the best interest of the child, of course, because this is the standard that the Chancery Court judge uses in Mississippi, state of Mississippi, in order to determine who will get custody of the child. Okay, we also have few factors on the Albright case. However, of course, the main factor will be the best interest of the child. So the person who gain custody, physical custody of the child, will likely have a temporary possession of home, because it also will depend on a school arrangement. There are also several factors which will come into play during temporary hearing, but the judge mainly will look at the assets of the parties, who is paying for what, who is contributing more, the best interest of the child. But in a lot of circumstances, when we don't have an issue of domestic violence, likely it will be joint custody, and then depends, on the circumstances and who is asking for a temporary use possession of the home. If they both asking for it, the judge also will look at who lives in the house now. Like in this hypothetical that you asked me about, the question, right? Who will get the house? Who is living in the house right now?
The mother of the child.
The mother, but the husband moved out.
Right.
Okay, and the judge will ask who had who was caring for the child prior to separation. So there are several questions that will be asked in order to determine who will get the house and whether he will be continuously paying a mortgage.
And if you file a motion, how long will it take for the judge, on average, to act on that motion?
Okay, well, motion for a temporary hearing, it goes to court really fast after the party is being served. Usually it takes to maybe up to 14 days to get back in court, to get to court in order for the judge to hear the case. I would say because you want to make sure that you serve the opposing party.
Right.
So it's very smart for a lawyer to get additional time for service because from my experience, a lot of people do not like to get served, and they will do very, very interesting things not to be served. People getting much smarter than they used to be, I think, because maybe technology contribution to that, so they kind of know what's going on and they feel the divorce is coming. And yeah, so it's I would say under the rules, rule 81 takes 7 days as far as the temporary hearing. However, I would say attorney always must have some time in advance because the process of service takes time, especially if we have a party out of state. So that's additional burden of to serve him or her.
Well, that information is good to know.
Okay.
That's why you go to an attorney, I guess.
Okay. So, how did your divorce go?
Mine went perfect, but it was uncomplicated. But she did a great job on it, and it was fast.
Okay, thank you for watching this video. If you'd like to contact my office and personally speak with Clayton, maybe.
I'll give a good reference.
He's my reference. Call my office 228-229-750 to set up your consultation. Goodbye.
Bye.